So far, this has been such a good day. I really have enjoyed all of the discussions. So, our third panel today is to talk about today's challenges. And we have some great speakers lined up for you, starting with Howard Shelanski. Howard Shelanski is a partner at Davis Polk and a professor at Georgetown Law School. He has held several positions in the federal government, including administrator of the Office of Information and Regulatory Affairs, an office that we're involved with today, the director of the Bureau of Economics at the Federal Trade Commission, chief economist at the FCC, and senior economist for the President's Council of Economic Advisors at the White House. Our second panelist is Dr. Robert Pepper, with whom I worked 30 years ago and many years since. Dr. Robert Pepper is a recognized expert on digital technology policy, working at the intersection of connectivity, infrastructure, and emerging technologies, technology adoption, and internet governance. At the FCC, he served as the chief of the Office of Plans and Policy and the chief of policy development for 16 years. Pepper also previously served as acting associate administrator of NTIA, served as head of global connectivity policy and planning at Meta, Cisco's vice president for global technology policy, and helped initiate a program on computers, communications, and information policy at the National Science Foundation. Our next speaker is former Commissioner Robert McDowell. During his time at the FCC, he focused on lowering prices and encouraging innovation to increase competition. And prior to joining the FCC, Commissioner McDowell was a senior vice president for the Competitive Telecommunications Association, or CompTel, and was executive vice president and general counsel of America's Carriers Telecommunications Association. And finally, we are joined by Tom Wheeler, who served as chairman of the FCC from 2013 to 2017. For over 3 decades, Chairman Wheeler has been involved in new telecommunications networks and services, experiencing the revolution in telecom as a policy expert, an advocate, and a businessman. As an entrepreneur, he started or helped start multiple companies offering innovative cable, wireless, and video communication services. He also previously served as president and CEO of NCTA and of CTIA. So I am delighted to have these esteemed speakers today to talk about, so what have we learned and what are today's challenges? And I thought I would start very quickly. We just heard in the last 2 panels about the past, but everyone on the panels has talked about how much has actually changed since in the 30 years since, a lot that we did not actually anticipate. So I would love to hear from each of you to talk about the current status of technology from your vantage point. And I thought, because I don't know how long we're going to have Pepper, given that he is somewhere in the Pacific, maybe we start with you while we can, and then we'll go around the table, so to speak.
Thank you, Commissioner. Yeah, you'll have me for the whole time because it's early morning here. It's about 6 a.m. Excuse me for my voice. So in thinking about, and listening, by the way, the previous sessions were terrific, and love the insights and the retrospective look. But back then, what we were focused on was competition, frankly, in the networks, right? And it was getting people connected. It was about the connectivity. And, notwithstanding all of the issues around implementation, competition worked, right? And even just the last question that Greg was addressing with, the death of long distance because of restructuring, the recognition that actually there was something called both economically, in terms of economics, but theoretically and practically, a termination monopoly. And once you broke the termination monopoly, you had competition, both, locally, long distance, and so on. And that's what we're seeing. But the shift today in terms of the technology, what we're really focusing on, and the big debates today about in technology that are then moving into policy, is that we're focused on what's happening up the stack, right? Yeah, connectivity, the connections are essential. They're the necessary but not sufficient focus of the conversation, right? Today, the big issues are about compute. Where will that compute be? What will happen with that compute? Who's going to control the compute? And that's why we have the not just the debates within the technical community, but also in the policy community and the press about data centers and foundational models and the competition, which is really good among the companies that are developing the new foundational models, and then questions about once you have these big foundational models, where's the compute? How do you use them? What are the applications? Do you need large models, or do you begin to focus on small models? The evolution of technology that we haven't even begun to have the conversation about, which is what happens when the compute power is put into your device. If it's going to be, my Android phone or my iPhone that is going to have the equivalent of a GPU that's being developed by Qualcomm, what am I going to need the data center for in terms of inference? I mean, there are a whole set of issues. We're at the very, very early stages of this transition, but a lot of it has to do with compute. What is the compute going to be used for? Who's going to be doing the compute? Who's going to control it? Will there be competition? And then what are the guardrails that we need around all of that compute?
Thank you. All right, Howard, you want to go next?
Yeah, thank you very much, Commissioner. Pleasure to be here. And, I hesitate to offer any thoughts when I've got Pepper and Tom and Commissioner McDowell on this call. But, I've, been batting these ideas around with all of these folks for a long time. I think I want to build on the point that Pepper just made, which is, things are moving up the stack. That's actually been happening for a very long time. If you think back to the very early open access debates that we had about broadband cable, that was really about, letting competing ISPs onto your broadband infrastructure. And gradually things moved up the stack to network neutrality. And what was network neutrality talking about? Not really infrastructure, but moving up into the applications layer. What was going to be what was going to be the ability of a wider variety of applications to get access to to that terminating monopoly or oligopoly. And then things have moved up even further now into the digital platforms that were originally thought of as beneficiaries of network neutrality, now controlling the gateway. And we have Judge Mehta having to decide whether Google controls vital gateways. Does Apple control vital gateways? These are all the kinds of problems these are all the kinds of issues that are emerging now farther up the stack. Now we get to yet another layer that is running on top of this infrastructure, which are these AI models of various different kinds. And I think the big challenge that emerges is how comfortable are we with both the scope and the I would say the market structure that seems to be emerging, with these foundation models. And to what extent do we want to avoid what many would say are the mistakes of the past of letting these platforms that emerge, whether it's 2 or 3 or 4 of them, also be able to have a lot of vertically integrated complementary kinds of products that effectively foreclose innovation or access by competitors at yet that higher level that's running on top of those foundation models. So what can we learn from the past about how to address these challenges? There's a lot being written now about principles of neutrality, principles of interoperability, principles of openness that are higher up in the stack. Should we require, for example, all of these foundation models to interoperate with all kinds of more specific complementary applications that might run on top of them? If so, what are the terms of access? How do we define and how do we price, if we price at all, that interoperability? And I think from there's some very interesting lessons that we can look. How do we on, in the telecom world? I mean, certain things like number portability are a form of, if you will, interconnection, interoperability that, worked extraordinarily well and opened up a widely competing, realm of basic telecommunications. Is there something like that we need to do or can do on the data front to enable different kinds of collaboration tools and sharing tools that might run on top of these kinds of platforms? If we look back on, just sort of basic interconnection from the 1996 Act, there were lots of, challenges and problems and difficulties about the level of interconnection and access that had to be provided, how that was priced, all the tower pricing debates. But at the same time, I think areas where interoperability mandates worked and interconnection could work. So to what extent can we draw on those past lessons from in the 30 years that have occurred since to help us think about these new technologies? I think there are tough challenges, and I'll defer in a moment to the rest of the panel to maybe talk about some of those in reaching those definitions. But I think there are going to be that whole history of interoperability, of openness, is going to be one of the things that we think a lot about. And just to make one shameless plug, you're probably all familiar Digital Crossroads first and second editions that John Nectarline and Phil Weiser wrote. Each of those having to do a massive update because of incredible transformations that occurred like over a decade. The last version of that book was 2014. The new edition is coming out. Phil's got a day job, so I have joined and co-written that third edition with John. It's coming out on MIT Press this year, but it talks a lot about what has changed and what the lessons are that we might draw for these new technologies, particularly in the last chapter. And if time permits, I'll talk more about those.
Thank you. That was great summary. Now we're talking a lot about really computing, or compute, as Dr. Pepper put it, and AI. Are there other markets that maybe we haven't had legislation or that have current challenges that we should be talking about? Rob, I thought maybe you could address that.
Thank you, Commissioner, and I'm humbled to be among such an august group. Happy St. Patrick's Day, especially to Carol Wheeler, who's been very involved with the Irish Embassy, and I've been her guest there a few times in the Washington, Ireland program. Wore my green tie. Shamrock. And I refer to Pepper as Dr. Pepper because we had a duck named Pepper once, and he met a fox, and it didn't end well for Pepper. So I will call Robert Pepper Dr. Pepper. So I have a space background in part because this call I was on was a space tech call, one of the fastest growing areas, as the commissioner knows, of sort of FCC land, if you will. Being a radio frequency chauvinist of sorts, I will tell my colleagues, a very large law firm, and by the way, I'm not speaking on behalf of any client, because probably some things I'll say could annoy them, hopefully not anger them to the point of firing me, but we'll find out. But that you can't do anything in space without radio frequency. You can't launch the thing. You can't steer the thing. You can't talk to the people on the thing if there are people there. You can't bring it back. You can't operate your robots on the moon to mine it or whatever it is you want to do without radio frequency energy. And that's regulated not just by the United States of America, but by other nation states and by international treaty, which I know Commissioner Gomez knows a ton about. But the U.S. so far is sort of leading commercial space, entrepreneurial
And AI.
Contemplated by the 96 Act. And by the way, first of all, thank you, Commissioner, for putting together this event. I worked with so many people who weren't even out of, diapers when the 96 Act was signed. So it's good to remind them how seminal and huge it was, hard to do by Congress, phenomenally bipartisan in nature, right? And had such a profound impact. And while it was not perfect by any means and litigated for years, there was a lot of good. And I know your previous panels have talked about that. But what was not contemplated was commercial space or entrepreneurial space. So this is a multi-trillion-dollar segment of the world's economy. We're in a boom right now. There'll probably be an adjustment. We might call it a bust later. But right now, there's a lot of investment capital with some fascinating ideas. But if you are a entrepreneur in this space, I have to say it at least once, you get to or have to talk to the FCC, Department of Commerce. So that's NTIA, the Department of Commerce, but also Office of Space Commerce, and NOAA and other offices in the Department of Commerce, NASA, FAA. If you want to launch your thing, you have to get their permission. If you want to bring the thing back to Earth, you have to get their permission again. Other folks at DoD, of course, NASA, DOT as well, other folks and many others. And then that's just in our country, right? And other countries like Germany or maybe Australia are trying really hard to make it easier for entrepreneurs to come there and kind of flag their space businesses in their countries, right? So that's something that needs to be looked at. It'd be great, ideally, if there could be some sort of one-stop shopping, or at least 1 or 2 or 3 stop shopping, if you're a commercial space company with shot clocks and other things. And also that kind of segues into spectrum, which is it's becoming harder to find spectrum to bring to commercial markets. Government users of spectrum, like the spectrum that they had, are reluctant to give it up anymore, to be kind. And then there's the government versus private sector. Then there's terrestrial spectrum versus space spectrum. And there's kind of less and less being allocated for space. Although we saw, I think, about 58% more launches of space stations, as we call the vehicles in space, last year than any other year, the previous year. And there'll be more and more over time. There's talk of, data centers in space, maybe 1 million satellites. We'll see if that actually happens. It's going to be very expensive in the trillions of dollars. But nonetheless, a lot of spectrum is going to be required if we want to do things in space. And there are many wonderful applications of space. Making pharmaceutical products in near zero gravity, for instance, can be done much more efficiently. Proteins and molecules form differently in near zero gravity, and in 4 milk jugs, you can provide a vaccine that could inoculate every person on the entire planet, for instance. So a lot of wonderful things that can help humanity and the planet going there. But I think we're going to need Congress to step in and figure out exactly what our space public policy is going to look like, and related to that, spectrum as well. If Marty Cooper were whispering in my ear, the inventor of the cell phone, he'd be saying the spectrum shortage is okay because it'll force everyone to become more spectrally efficient. So I have to say that in honor of my 97-year-old friend, Marty Cooper. But nonetheless, every device you can think of is gobbling up more and more spectrum, and it's causing friction, right? A public policy headwinds. So kind of in a coconut shell there, those are some issues that maybe the 96 Act needs to be reopened, so we can solve those problems too. And hopefully in the same bipartisan spirit the 96 Act was born into.
Thank you for that coconut shell. So Chairman Wheeler, you come to this with some perspectives that you've been talking about with regard to particularly artificial intelligence. Obviously, I'd like you to talk about anything you want to talk about, but I was hoping you might tell us some of what you have been putting out there in terms of what needs to be done to ensure, to ensure that the market remains competitive and innovative and that consumers benefit and so on and so forth.
Oh, that's all. Well, first of all, Commissioner, what a great idea to do this today. Thank you for doing that. I've been here since noon. It's been a trip down memory lane. I mean, wow. And the other part about it is that all of the folks who preceded the panels, the service that they gave, the intelligence and the dedication that they brought to their tasks. You included former staffer Gomez, were incredible. I said to Reed Hunt one time that I thought his greatest contribution as chairman was the quality of the people that he brought to the commission and changed the intellectual fervor of the commission, and so much of telecommunications afterwards. So, I mean, it has been wonderful listening to all these folks. Now, I've been filibustering after listening to my colleagues here, because it's awfully hard to follow that kind of wisdom. But let me pick up once again in the leadership that Pepper has shown in getting us all to talk about things in his terms. And that is the question of the stack and how everything is moving up the stack. 96 does not exist anymore. Maybe you noticed that. In 96, the internet was AOL. Media policy was cable and broadcast competition, contention, better than competition. Telephone, as we've heard, was all about post-breakup and long distance. Spectrum decisions were made on the basis of analog physics, not digital physics. And everything we talked about was narrowband, not broadband. To go back to Pepper's line about the stack, that's the lower part of the stack. And they're all important kind of things, but the question is, what are they doing to facilitate the top of the stack, which are applications that affect people, affect productivity for the economy, and define what the future is? And unfortunately, we don't have a structure because it is based on 1996 realities that equips us to deal with that. We need to have, as Howard said, a competitive environment. We're in the process right now. 2/3 of all the cloud compute capacity in the world is controlled by three companies right now. You cannot build AI unless you have access to compute power. It's a bottleneck. The models are bottlenecks. Even quasi-open or open weight models are bottlenecks because middleware has been put in between them and the frontier models themselves. So you have to ask yourself, in that kind of an environment, is there a relevance for the FCC? Or the FCC, an agency created to deal with the lower part of the stack, created under structures that were based on analog assumptions. Is that agency capable of dealing with the application of the lower sectors of the stack to the new digital AI-based applications that are in the process right now of changing our world? And that problem becomes even worse post Loper-Bright and major questions doctrine. Because if anything, what we need right now in technology is agility. And if anything, statutes aren't. And I loved, I think it was Gina Keeney's comment early on where I think she was quoting Billy Tozan as saying that people understood they wouldn't pass it because you can't make the tough decisions and get people to vote for it. So our challenge going forward is, will our policymakers in a frame larger than the FCC at the White House and in the Congress have the vision to say, hey, the world has changed. We can't keep relying on the assumptions and the structures and the statutes that we put in place 30 years ago. We've got to do something today. And as we heard in the previous panels, the key to that happening before was a bipartisan coming together around a common sense, common set of ideas that were trade-offs with each other, as we heard quite explicitly? And are we capable of even doing that today?
Yeah, I'm so glad you brought up Loper Bright and the major questions doctrine, because one of the things that I think a lot about is with regard to the 96 Act, there's so much about the market that evolved that we had no idea was coming. And I one of the things I think about is, to the extent we were advising Congress to pass legislation to address today's challenges, whether it be in space or whether it be artificial intelligence or up the stack, as you guys call it, how do we address these issues without freezing in time the state of technology? In the end, listening to all of you speak, I hear kind of echoes of the issues that Congress was trying to address back in 96. What are the bottlenecks? How do we introduce competition to them? What's the number portability in our future or current or galloping into the future right now? So I don't know if you have thoughts on any and all of that, and I don't have any specific person I wanted to tag with this. So maybe start with Howard, since he's got some deep thinking on generally the state of technology and regulation.
Yeah, so I mean, I think that there are two separate questions. I mean, one is, what can the FCC do, and the second is, what might Chairman Wheeler's theoretical new agency do if we were to have sort of an agency that was really purpose built for addressing some of these concerns? What would a new statute, what would a new sort of administrative system look like? I do think that the FTC's lever on a lot of these issues is, after Loper Bright and after West Virginia against EPA, fairly limited. If there was a tenuous grasp on being able to get network neutrality, I think being able to designate things farther up the stack as being within scope of the statutory authority of the agency seems a much bigger risk. And, Congress has hardly given guidance about what it thinks should be done in these emerging areas of technology. And when you consider the extraordinary impact on everyday life, the extraordinary amount of money, and sort of the dependency upstream on two major inputs, power and compute, it really becomes something that probably does need, as Commissioner McDowell, as Tom Wheeler said, a new statute and a new way of thinking. So what should that new statute do? And here I think there's a real reason to hit pause and to think about what technology are we talking about when we're talking about, say, the big foundation models. Well, right now there's a really intense competitive horse race going on amongst 3, possibly 4 providers of such models that are US based. Well, 3 that are US based, 1 that's France based, and probably a handful, but certainly 3 or so that are China based. And let's put aside the Chinese model developers. Let's put aside Mistral in France, and let's just think about Google and and Anthropic and OpenAI here. That's a very different kind of competitive horse race than the kind that we were talking about, for example, even in the emergence of wireless, that depended on government allocations of spectrum and things like that. And so the question is, what kind of regulation is needed to ensure that competition doesn't get arbitrarily cut off, and that those foundation models can continue to compete? And for example, Google, just to pick an example, can't use certain kinds of incumbency to drive use of its models, that Microsoft can't, use its incumbency and its, sort of presence and collaboration tools to drive, its models or its services. And various kinds of concerns like that. I think that there is a set of principles, both from antitrust law and from telecom law, that could be drawn on. But right now, those are all being done, I would say, through ex post competition enforcement, antitrust enforcement. And you've got the antitrust agencies looking at those issues, but without a purpose-built statute for thinking about kinds of duties to deal, kinds of interoperability, kinds of interconnection that are, I would say, on tenuous doctrinal ground in antitrust law and without statutory development. So, should that be where where the regulatory, issues sort of focus? And then what I said before about making sure that ecosystem stays vibrant. Do people who use a particular foundation model have the ability to use lots of different complementary products, to access their own data across different platforms? I think these are going to be sort of the questions of the day. And I don't see right now whether it is in, you can try to stretch antitrust law to get there. I think it'd be very hard to stretch telecommunications law and the regulatory authority of the FCC to get there. So we probably are going to need at a certain point after this market shakes out a little bit to have some hard thinking at the policy level. And that's going to, I think, have to be legislative.
Can I pile on that for a second? Because I think Howard raises some really good points. I mean, I would have one difference that you talk about the horse race, Howard. Yeah, there are 3 folks who appear to be in a horse race. I'm worried about other people getting on the track. All right. And the 3 folks that you name dominate the American tech stack. I mean, let's just look at the tech stack for a second, in basic terms. We got chips at the bottom. You got processing built on top of that. And then you got models built on top of that, all of them working up to deliver applications. And what we want this horse race in applications. But the trouble is that the folks who are on the track down here below control these steps to get into the ability to have an applications horse race. And I agree that antitrust law, as important as it is, as much as it needs to continue to be pursued, that it is ex post, it is far too slow. By the time that the Google decision finally gets, the search decision finally gets out of the court, it's going to be irrelevant. And so how do we deal with that again in an agile way? And it seems to me that, yes, as you've referenced, we need some kind of a new structure, but more important than that, we need a new way of thinking, that we can't bring the kind of regulatory micromanagement to this dynamic marketplace the way we have seen in the history of the FCC and other agencies. That what we need to be doing is saying, okay, here are the expectations. This is how we expect you to behave. You go and determine the route to get there. But I'm telling you, this is wrong, and this. We're not going to tell you how to run your company, but we are going to tell you that the society has a right to establish expectations and hold you accountable for them.
So let me jump in for a second and agree, but then disagree a little bit. So I do think that what Tom said about, not focusing on micromanagement, but setting out sort of functional, what do we want to achieve and what do we want to avoid? And you figure out how to make that happen, right? I think that makes a lot of sense. But we also need to separate what are the issues that we're concerned about in that context. I do not at this point agree that we have bottlenecks among the models. I haven't seen that. And what we don't want to do is prematurely have sort of ex ante requirements. And Commissioner, you alluded to this, that create lock-in for the today's large models. And you want to be able to, and that's the problem, right? It's very different to have number portability for telecom coming out of an analog world. It was, narrow. It doesn't require sort of an interoperability of a model that has billions of or hundreds of millions of lines of code. What does that mean at this point? I mean, people I work with are developing applications, downstream applications for, whether it's in the pharmaceutical area, building on, identifying, new molecules, or transportation, or in emerging markets, food security. These are smaller models that they are developing using some of the large foundational models, and they're drawing on all of them. And what they're doing is they're having Claude, check something that they've developed on ChatGPT. And so the downstream, people on the downstream application development are using multiple models to improve and to check what other models are doing. So we have not yet seen, right, a bottleneck that does not allow for that kind of work. And I think we do have to be concerned if we see that, but it's not yet happened.
Bob, I think you're missing, I will shut up here in a second, but I think you're missing the business perspective here, which is that for model builders, the big three that Howard talked about, for model builders, their problem is they have an incredibly expensive asset that they can barely pay off out of their earnings thus far, and are being forced to go to the application layer. It's the only smart business thing to do, is to continue to move up the stack. When they become the players where where they are competing with their competitors, if you will, because they control the lower levels of the stack, that is an issue that we need to be worried about prospectively, not, oh my God, look at this mess.
No,
how do we cut the baby in half here?
No, I agree. You're talking again, very analogous to what we were dealing with in '96. Is there an essential input that a new entrant needs, right, from somebody who is
right,
embodying not just that essential input, but also competing at the, it's not the application layer, but competing in, the product that I'm trying to build. So I agree with that. But, I think what we have to be careful about is prematurely thinking we know how they're going to do that, or even if they're going to be successful. And what we need to have ways to monitor that, to see if in fact, problems evolve, and then how to address them. We can't be blind to it. I completely agree.
We heard that the Telecom Act was a 6-year process. Okay. There was nothing premature there. Okay. We found to start having this discussion now, and we're not having it, other than God bless Anna Gomez for getting us in this environment to have this kind of debate. But have we had this discussion before the Congress? I remember that there must have been 50 hearings on the Telecom Act by the time it finally passed. And they were educational hearings. They weren't performative hearings. They were, how do we learn? I'm done. I'll shut up.
So I know we're going to pivot here to Q&A here in a few minutes. So a lot has been said, but not everyone has said it yet. So real quick, let me comment on a couple of things as we segue maybe into Q&A, which is, first of all, a clarification. I think Loper Bright gets misunderstood. I'm old enough to where when I went to law school, Chevron was a relatively new case. It was 1984. I entered law school in 87. So it hadn't been Chevron yet. It wasn't quite, it was, okay, one of many cases you studied in administrative law. And the end of Chevron doesn't mean the end of agency expertise. It means that courts won't defer to an agency interpretation of its own statute when that statute is ambiguous, right? So I want to give some hope there, right? So what I remember when Loper Bright was handed down, I saw friends on the sort of libertarian right pop champagne corks and folks on the left start crying and throwing themselves out of windows. And I said, "You're both wrong. Knock it off. Sally forth. You'll see an agency's opinion is still given weight, is just not given deference." So that's important to understand. And then there are some building blocks. Like, it's going to take a long time for Congress to rewrite any of these laws. They'll probably be more surgical or narrow than anything. It can't even pass a comprehensive nationwide privacy bill, right? That's been going on for 20 years. But if you look at, I'm going to take Spectrum as one example, which is flexible use policies. I think they started being introduced in the first Bush term or thereabouts under Michael Powell. But that has allowed for more efficient use of spectrum, one could argue. Others have gamed it, no question, to warehouse and be spectrum flippers, and that's a problem. And the commission, however, does have, the FCC, the best agency, does have the tools, the legal tools to enforce against spectrum warehousing or inefficient use such as that. But flexible use has led to an explosion. So I was at the commission starting in 2006. And 3G was still the standard, and we were trying to plan on the spectrum auctions that would take us to 4G. And I think that was a quantum leap once we got there, but we weren't micromanaging 4G. The iPhone debuted in my second year on the commission in 2007. Nobody really saw that coming except for the wonderful engineers at Apple, right? And didn't know that they needed it, but it was born in a 3G world. And unless you're on a Wi-Fi, it wasn't much good. So once we got 4G more ubiquitously built out, then smartphones became a thing. Then that led to an explosion in the application layer that's been the topic of conversation here, right? So that has been, we're talking on an application right now, and yes, it's owned by a very large company, but there are millions of apps out there, many created by folks in their houses, on their own, not by large corporations. And that has contributed tremendously to the world economy and improved the human condition overall. And there are some that aren't so good either and have done bad things as well. But net, a big positive. So I think we need to keep that in mind as we go forward. And there's the debate between ex ante or common carrier style regulation. The term net neutrality was born in 2004 by Tim Wu, that. Everyone knows my position on that. I don't think it was needed. I still don't. I think competition law takes care of the parade of horribles that was always marched out to say we needed them. But nonetheless, competition law is important and enforcement of it is important. I think those are two things we can glean from what some of the speakers have said. And you need to watch. But it's been such a wonderful whole TMT, telecom, media, tech marketplace, a dynamic, fast-moving marketplace. It's been absolutely amazing to watch. When I was sworn in on June the 1st, 2006, the largest social media platform was MySpace. Twitter was in its infancy. Facebook was still in its infancy. And that changed rather rapidly. So why is that? Because incumbents can be disrupted. And yes, you need competition antitrust law to make sure that incumbents aren't abusing their incumbency or their market position. And I think you're going to have to rely on that, realistically speaking, to make sure you have competition going forward, because it can be very difficult for Congress to legislate anything specific in the meantime. And I know now we're probably up on Q&A time, so I want to defer back to the commissioner who actually has statutory and constitutional power, not like a has-been, Tom.
That's right.
Sure. Well, I did want to ask one more question of my own. I like to think about these issues in human terms. So when we talk about regulating today, we talk about making sure that everyone in the United States can get access to telecommunications or to communication services. For example, we worry about consumer protection. We want to make sure that people with disabilities can access all of these technologies and more. And so I'm curious what you would say would be the first line of the act about the purpose of any future legislation on these services. The Communications Act says that, it's for the purpose of regulating communication by wire. I'm going to paraphrase because it's really long. so as to make available, so far as possible, to all people of the United States without discrimination, a rapid, efficient, nationwide, and worldwide and radio communication service for the purpose of promoting safety and life and property through the use of wire and radio communications, and so on and so on. What should be the words in any future legislation that enable whoever does this? And I've heard a lot of people say it shouldn't be the FCC. Maybe, and you know, Rob, you said there's too many people involved in space. At least that's as far as I heard it.
Too many agencies.
Too many agencies. But if Congress legislates, what should be the primary goals, and who are the beneficiaries in the end of those primary goals?
I'll be real quick with an answer and let others follow, which is I think the first three words should be do no harm. I could also go on to say don't screw up, but do no harm and go from there. But go ahead. I want to hear what the others have to say.
I'm sure the courts will take that. Absolutely. Howard, I don't know if you had something, or I saw you lean forward.
Yeah, I mean, I do think that there's, you know, I think a lot of groundwork has to be done before we know about the need for legislation, as Commissioner McDowell just said. And I do think that when we're even taking Tom Wheeler's point very much to heart, I think there's a question about, you know, we don't know how people are going to go up the stack, or even whether that's a bad thing to have, you know, various integrated alternatives. But I think what I would say is that if we're going to have a statute, it should say to preserve a marketplace most conducive to innovation and competition. But I would probably focus on innovation, say to preserve incentives and the ability to succeed through innovation.
So I would agree with Howard in terms of we're starting with that specifically. But one of the lessons of the last several years is one of the things I was doing was working with the Economist Intelligence Unit. We had a 6-year time series study that we were working on called the Inclusive Internet Index, and took a look at about 100 countries globally, looking at about 54, 55 indicators for each country. And as part of that research, the Economist Intelligence Unit came, and we called it the Inclusive Internet Index. They came up with that term, the Inclusive Internet Index. And the reason they did that was it was not just about being connected to the internet. It was being able to use and benefit from being connected to the internet. And so when we think about, you know, with the Telecom Act, when we looked at the digital divide, it was who's not connected. There's affordability on the connections, is, you know, the network available, et cetera. That was about being connected. But for everybody to benefit, there are other aspects, right? So it's not just being connected to use it, but there's a whole set of skills. And some of the big issues that we're, you know, looking at with AI is job replacement, or having to reskill, and how is it going to have an impact, both positive and potentially negative, on people's lives. And I think that as a society, we need to think about how does everybody benefit from these developments. But I would start where Howard started, because it is about innovation, but we also need to build in from the beginning, all right, a focus on universal benefit from the technology.
So
development.
I think you're spot on, Bob. The term public interest, convenience, and necessity in the 34 Act is an abomination in terms of instructions. It has created the environment that we're now seeing, where the FCC is intimidating people in their free speech rights by saying, hey, it's not the public interest. I agree with Chairman Carr when he proposed that we need to have a rulemaking defining what the public interest will be. That would be an interesting exercise and a debate worth having.
I almost fell out of my chair there for a second. Sorry, go ahead.
But to Howard's, do I agree with that part? Well, I think
I was waiting for the rest of the sentence.
but I think to Howard's, but with Howard and Bob's point is that we're going to have to be specific in expectations. You know, I mean, where's the expectation of privacy in this discussion? Where's the expectation that there are going to be effects? How we had never sat down and said, here are the kind of effects we would like. Public interest, convenience, and necessity. Just and reasonable. No, we need down to get to a situation saying, well, what do we want this to look like? And those are, I can't answer that right now, but those are tough questions that need to be debated, and we need to have specificity in a general instruction that has to then be interpreted.
Yeah, I think that's right. One thing that John Windhausen said was, you know what, he doesn't think we know enough yet about where this is all going and to create a whole regulatory agency. But instead, Congress should create a commission. Wait, was it a commission to study, to issue a report?
Yeah.
Basically making recommendations.
Well, it's a better suggestion than what we've seen in the executive orders, for instance, that say that where the president instructs Brendan Carr to have a rulemaking that will start determining what states are allowed to do with regard to AI. You know, that's an instruction to your agency right now that we're not talking about, but we sure need to be talking about.
Yeah, as you've mentioned, our authority is questionable under the existing statute on some of these issues. I do have to say there's sort of on the edges, we probably had some authority simply because of our regulation over the carriers themselves, the spectrum, things like that, robocalls. I did want to ask one more question. One thing that we learned and that I really heard from the first panel was that the reason Congress was able to get legislation through was that every party wanted something and every party was willing to give something up. So it's all about incentives. Does this exist, A, in the space arena, and I think that's pretty easy, and B, in this new artificial intelligence marketplace that is just really rapidly developing?
I'll comment briefly on space, and then I'll let others answer the rest, which is, there's a lot of common interest, a lot of common thinking about what entrepreneurial space companies need. And so I think you'll see a lot of agreement there. There will be disagreement at federal agencies about their jurisdiction, however, right? Plus, all those agencies I mentioned at the outset, those are different congressional committees with jurisdiction. So Armed Services Committee, Commerce Committee, Science Committee, transportation committees. And so to get different committee chairs to agree on something a la the 96 Act is going to be really hard. The 96 Act was primarily a Commerce Committee act, which actually one could argue started right after the MFJ, the breakup of AT&T modified final judgment in 1984, all the way through 96. So that took maybe 12 years. I heard, 4 or 6 years earlier, and maybe that's being kind and generous. I think it took even longer than that. So I think, however, entrepreneurial space can agree on a lot. And maybe there could be a skinnier piece of legislation regarding all that. As far as all the other industries in sort of communications world, FCC land, I'll let others answer that question.
Howard, I know you need to leave. I don't know if there was something you wanted to add, or I can just say thank you.
I can stay for 5 more minutes.
Okay.
But all I'll say is I do think that I can't speak to the space context, but I think in the AI context, you do have you might have a large community of folks that have differing interests, but might all have something to gain and to trade off in legislation. Again, I don't think we're there yet because I think we don't know what those trade-offs are, and I think that we don't know even if the participants themselves know how the market's going to shake out. So I think I'll just conclude my remarks quoting the great Chairman Bill Kennard, who, when urged to regulate early broadband, said, "We don't have a monopoly, we don't have a duopoly, we have a noopoly." Well, it's a little bit of a different situation when we look at the the AI sort of universe. We do have a race that is emerging, and some might try prematurely, I think, to call it just a triopoly or something like that. I think there's a lot of competitive ferment still. And I think we just don't know what kind of market we are looking at. But one thing just to be very mindful of, it's a lot easier to be successful when you're regulating a clear monopoly. Your regulation's more likely to do good than harm than if you're regulating a competitive space. The more competitive a market is, the less margin there is for your regulation to improve over what the market will generate. And I think we should be very mindful of that as we think about any regulation going forward, and make sure there's a need for it, but not to wait too long that need can no longer be served.
Thank you. All right, so we're basically out of time. I don't know if there's anything quick that Pepper or Tom want to add.
Well, if we're going to do AI, of course, Tom has something to say. But if we're going to be talking about AI, the challenge with AI is that we can't grapple with AI, the huge AI.
Yeah.
You can't get your arms. You got to break it down into its parts. Okay. What are the effects of AI? We bias, discrimination, fraud, those kinds of things. What is the situation that creates the environment that delivers those effects, i.e., back to the conversation we've been having all along about competition. So we need to parse the issues. Otherwise, we are going to be in a mosh pit that we'll never be able to get out of because the goal is too broad and generic.
All right. Well, we started with a quote from the Rolling Stones and we ended in a mosh pit. So I think that's a perfect way to end this panel. Thank you so much for giving your expertise. It's really been a terrific conversation. I could have gone on much longer. So please help me thank our talented panelists for this spirited conversation about the lessons of the 96 Act and how we can apply them to today's communications and technology challenges.